All right, so we're going to start off with Carey versus Population Services. In this case, the question of Griswold and the extent of the protection in Griswold, not only the privacy protection, but the contraceptive protection, is extended to the population as a whole. So in this particular case, the state of New York had a law which prohibited the distribution of contraceptives to those over the age of 16 by anyone but a pharmacist, and it prohibited all sales or distribution of contraceptives to anyone under the age of 16. So you could get contraceptives because of Griswold within the confines of a marital arrangement, but it was not available to the public generally. I mean, some states certainly allowed them to be available to the public generally, but other states restricted it because the precedent in Griswold did not go that far. And so the question in this case is whether the law in question is a violation of the inherent right to privacy as established in Griswold. So basically, does Griswold go farther than just the marital bedroom with regard to contraception? And the answer that the Supreme Court gives, in this case, Justice Brennan writing the majority opinion, is yes, it absolutely it does. The law in question is unconstitutional, not because access to contraception is a fundamental right, but because access to contraception is an essential exercise of the constitutional right concerning childbearing under Griswold, so that individuals have the authority to determine whether to or whether not to have a child, and that is what extends from Griswold. Now, the reason New York passed this law, or at least argued that they passed this law, is interesting. New York argued that if contraceptives aren't available to those under the age of 16, then these kids simply wouldn't engage in sex, which, is stupid. So the reason why they passed these laws, arguably, at least as they claimed, was to decrease teenage pregnancy, which I'm not sure how they could actually make that argument with a straight face. In this case, Justice Rehnquist dissents, and his dissent is a similar to dissent we see many conservative jurists making as laws begin to liberalize and these privacy protections begin to be extended. Justice Scalia makes a very similar dissent in the 90s. What Justice Rehnquist says is that if the patriots who had died during the Revolutionary War and those responsible for the drafting of the Bill of Rights could see the effect of their work, they would have no understanding how the Constitution somehow mandated the protection of commercial vendors selling contraceptive devices. It's conservative in the nature of it, wants to slow the evolution of law, but it's also conservative in the nature that it's hearkening back to these founders when contraceptive, at least predictable, reliable, available contraception was absolutely not even available. So he's reading something into the founders and the patriots who died during the Revolutionary War, reading something into them that would have absolutely not ever even crossed their mind. And so his argument that they would be upset that the Bill of Rights protects against this is at one point awkward, and on the other point disingenuous. So this seems to be an establishment that substantive due process, because that is how this right is read into the Constitution, substantive due process is now back. It wasn't just, so Griswold wasn't just a bump in terms of the timeline, that it actually signaled the willingness of the court to increasingly use substantive due process to incorporate more into the Constitution, more protections applicable upon the state by the 14th Amendment.